Hi guys. So I'm here with my friend Tom Kuzera, who is a real estate attorney in Florida, and I've been getting a lot of questions from Lady Bird deeds to quitclaim deeds to how to protect your spouse, and he's here to talk to us about it and tell us a little bit about the difference between the deeds and what you should do based on your different cases. Hey Tom.
Gretel, how are you?
Good, good. Having coffee.
Good for you. So, so there's a big difference between a quitclaim deed and a ladybird deed. Okay, a quitclaim deed is a transfer of a real estate from grantor to grantor. A grantee. A grantor is usually considered the seller. Grantee is the buyer. That's the person to whom the property is transferred. A quitclaim deed is an instrument that is executed by the grantor. Let's just say in this case, it's you and you want to transfer your house that you own free and clear. It doesn't have to be free and clear, but for this example, there's no mortgage on the house, and you decide to transfer the property to me. The fastest way of doing this, and the easiest way, is a quitclaim deed. Um, the benefits of the quitclaim deed is that you transfer any interest that you own or have in that property. So if you own the house 100% free and clear as a fee simple absolute owner, and you execute a quitclaim deed in front of a notary and two witnesses, and it's properly signed and recorded, then you transfer effectively, transfer your entire house to me. And that's the end of it. The downfall of quitclaim deed is that you do not warrant the quality of title. The definition of quitclaim deed is that you transfer any and all interest you may have in that particular property. And in your case, yes, you own the house 100%. There are no other owners. And then the effectiveness of the quitclaim deed is that you transfer the whole house to me. But because the definition of quitclaim deed is that you transfer any and all interest you have in the property, there is nothing wrong with me executing a quitclaim deed to Coral Gables City Hall and transferring it to you. And people may ask, well, how can you transfer a Coral Gables City Hall to Gretel, Thomas, if you don't own it? Well, all I'm saying is that I'm transferring any and all interest that I have in the City Hall to Gretel. What interest do I have in City Hall?
Gotcha.
Nothing. So it is not necessarily illegal. It is ridiculous to do it. And absent of me telling Gretel that I own the City Hall, which is fraud, I really did nothing wrong under the common law. But truly, the definition of quitclaim deed is a transfer of any and all interest in a particular piece of real estate to a grantee without any warranties of title. So many people do it. They transfer properties from their personal name to their LLC or vice versa. And it is a very effective way and the simplest and easiest way of transferring a real estate without doing title examination and warranting quality of title.
So you don't get title insurance, right?
You do not get title insurance when you transfer by virtue of quitclaim deed. Correct. So, most of the closings, the real estate closings that we handle and that you are familiar with is the transfer takes place by virtue of warranty deed or special warranty deed. And by its own definition, warranty, you are warranting the quality of title, marketability of title, and you're pretty much telling the buyer that the property is free of any encumbrances, no mortgages, no judgments, no liens, etc. Okay. Just to dip a little bit into the special warranty deeds, those are usually used by developers. And a special warranty deed is also you're warranting the title, but you're only, as the seller, as the developer, you're only warranting the quality of title for the length of the ownership that you own the property for. Versus warranty deed, you pretty much guarantee that from the time you transfer the property to me, you warranty the quality of title all the way to the back of time. And by that, I mean, I guess, when Florida was subdivided by the people that subdivided Florida many, many years ago.
Okay. So
So,
if I live with someone, we have kids, right? And I want to leave my property to my kids. And my kids are not 18 in this hypothetical scenario, right?
okay.
If I Lady Bird deed, Will my kids be protected? Will the other person be protected? How would that work?
So I always warn people about transferring title to real estates to minors. It is not difficult to transfer property, say from you to your children. It is, however, difficult to transfer the title from the minor children to somebody else. So if you transfer your property, whether it's warranty deed, quitclaim deed, any kind of deed, from you as an adult to your minor children who are under the age of 18, then yeah, they will effectively become the owner of the property. But because they're 18, the law presumes that they don't have rights to contract. And if they wanted to transfer the property to somebody else, and at that time of transfer, they're not 18 yet, there will be need for guardianship. And I'm not going to get into the details of the guardianship, but I always warn my clients about transferring their property into a minor children. There are other ways of doing it. You can transfer it into a trust in which the children could be beneficiaries. In that case, you do need a trustee. You, as the transferor or the grantor, could be the trustee of the trust in which the children are the beneficiaries. And again, I don't want to get into details of it because this video will be very, very long. But that is if you decide to transfer property to your children, um, whether it's by quitclaim deed or Lady Bird deed or any kind of deed. Um, let's just say your children are 18 and you, and we spoke briefly before this, you want to make sure that one day when you die, the property that you currently own will be vested in your children. There are various ways of doing this. One of them is a trust, or there are different kinds of trust, obviously. But one of them, the most simple and easy way of doing this is what's called life estate deed. There are two types of life estate deeds. One of them is just a life estate deed, and one of them is called Lady Bird deed. A lot of people use the word Lady Bird deed. The proper name for it is called enhanced life estate deed. Okay. And it works this way. The simple life estate deed is where you, Gretel, transfer the title to your house to yourself for life, with the remainder to your children. If you do it just like that and you do not mention any other wording of enhanced life estate, once you execute the deed and record it in the official records, you cannot take it back. And all it means that you transfer the property to yourself for life. You can enjoy the property, you can live there, you can even rent it, but you no longer can sell the property to somebody else without the written consent of your children because their interest is vested. Their future interest is vested, and it only vests when you die. But with the simple life estate, you cannot sell the property to somebody else without the signature of your children. The enhanced life estate, which is Lady Bird deed, there's a whole history of why it's called Lady Bird deed, but that's unimportant right now. The Lady Bird deed works like this. Gretel transfers title to her house to Gretel for life. And then there's a long language in which Gretel reserves the right to sell the property, encumber the property, mortgage the property, and all other hosts of things without the consent of the remainder men or remainder persons, to be inclusive, of your children. And then upon her death, the property transfers to your children. If you take that deed and record it in the official records, you have effectively transferred the property from yourself to yourself for life. And if you do nothing else during your lifetime, when you die, the property will effectively transfer to your children. All they have to do is take a copy of your death certificate and record it in the official records, thereby advising the clerk and the world that you died. And at that point, the property transfers to your children without the need of probate and any other judicial procedures.
So,
But yes.
does it get recorded prior to me dying?
No, yeah, you record it upon execution. So,
Oh,
right. So the Lady Bird deed, and that is the one that most people are interested in because they
yeah.
don't want to give up their rights
I
of
a
do.
lot about it. in the last week or so, I've gotten at least 4 or 5 people asking me about this.
Right. Yeah, it's I see more use of ladybird deeds now than ever before, and the reason is simple. It is very effective. It is very practical, and effectively, if you transfer the property to yourself in enhanced life estate, reserving the right to transfer, the sell, the mortgage, the property to somebody else, you can still do it even when you execute the deed and word it the way I stated. Then you still own the property. You can live in the property. You can rent the property. But for example, if you want to sell the house 2 years from now, you're still alive, obviously, then you can do it without the signature and consent of the remainder person, which is your children. So you actually retain the complete control of the house and the interest in the house. And that is the main difference between a simple life estate deed and the Lady Bird deed. They're both life estates, but the Lady Bird, you reserve the right to do whatever you want with the property, including putting a mortgage on the house, selling the house, using the house as a collateral against the loan without the express written consent of your children. And that is why Lady Bird deeds are more and more popular. It's a way of estate planning.
Yeah, I mean, I guess it's the age, man. All my friends are getting older, so I'm getting all of these questions. Everyone's,
Yes.
I'm in the road. What if something happens? And I'm like, and you don't have a will? And they're like, nope. And I'm like, time for you to make a move. So,
Right, right. And many people they regard will as the be all and end all, but even the will, I don't like the use of will for real estate because there's no need for it. Even if you have a will and you die tomorrow, you own your house free and clear by yourself, nobody else is on title, and you die, and you left your will behind. And in the will, you state that upon your death, this house should go to your children. You still have to, or your children still have to open up a probate and go before the circuit judge and determine, number one, whether the will is valid, whether it was properly executed, and then the judge will interpret, it will read the will and make sure that the will is proper, and then only then the judge may determine that the new owners of the property are your children. So I discourage my clients from using will for the purpose of transfer of real estate upon the death of the owner of the property. So
okay.
Lady Bird deed, no need for probate. It's operative on its face. You record it upon execution, just like any other deed, and it's recorded in the official records of the county where the property is located, and it's effective. And also, you can retain your homestead protection, everything as if you still own the property. But God forbid, school bus runs you over tomorrow and you don't make it. You're
That's not the case.
yeah. Well, we never know what the future holds. This is hypothetical, obviously, but you can sleep knowing that God forbid something happens to you, the house goes to your children without the need of hiring a probate attorney and leaving it, so to speak, in the hands of a circuit judge.
That's awesome. Hey, thank you so much. I'm gonna let everyone know. I'll put up your info if they need any help with any of all of this paperwork that they might need to reach out to you. So anything else that you want to say? Because I'm good. Those were my questions on my end.
But no, that's good. I'm gonna share a screen right here. I know you told me not to, but I want to share. Do you see it?
Yeah, I can see it.
Okay. I did it quickly. It's not very professional, but there you see the information for me and also for you. Obviously, for those of you who don't know, Gretel is a real estate broker, a very good one, and I do real estate law, civil litigation. I also represent condo associations, and I've been an attorney for almost 20 years. So it's been my pleasure, Gretel. Thank you very much.
Thank you, Tom. Take care.
You too.
Bye.